Good afternoon. Apologies for the attempt to appear as though I was freeze-framed then. As the front slide says, we were just waiting for the participants to come into the webinar. And thank you very much for joining us live on a lovely sunny afternoon. Apologies for that. It's fairly warm in my room here. I'm sure it's the same with you. I'll do my best to cover what we need to cover in adequate, competent detail, but not at tedious length. I recall that when I was at university, one of my first professors there said that, frankly, anyone's attention span is probably limited to about 20 minutes. Of useful information. That probably is true of me talking. It might even be quite a bit less than that. But there's the topic today is, as we say, driverless cars, from negligence to product liability. And I think when the invite went out, the question mark wasn't at the end there, but on reviewing the detail of this topic and really getting to some of the interesting questions about product liability, and particularly looking at the Law Commission's view about matters, there's probably a bit of a question mark about how far product liability in its current form is going to help us, but we'll certainly touch on that at the end. Here's a statement of intent by the Department of Transport back in 2015, when a report was commissioned into the prospect feasibility of the operation of driverless transport on the British highways. And you'll see there that what was said, that it was a major opportunity, and reason for that was that Britain was very keen to offer itself up as a haven of relatively light regulation that would enable these sorts of technologies to be trialled and put into operation on the roads. And part of the point there was that it was said that drivers could safely use the driving time however they wish, from reading a book, surfing the web, watching a film, or just chatting face to face with other passengers. Well, and that's an admirable objective. Query though whether the technology is quite at that stage yet, and some sad examples, unfortunately. There have been at least 3 fatalities that have been attributed in whole or in part to failures on the part of driverless vehicles. There's also there's a 4th fatality as well. I've left that one off because there's a query as to whether autopilot was actually engaged in that case. But these 3 individuals all lost their lives as a result of collisions involving driverless vehicles. Gay Yuning was in China driving a Tesla on autopilot. And it was a very hazy, smoggy day, as happens in industrial parts of China. And his vehicle drove into collision with a lorry on the hard shoulder that simply hadn't been picked up by the sensors, and sadly he lost his life. Joshua Brown, an American in Florida, he was a great advocate of this type of technology. I think he owned his own technological innovation company and often posted YouTube videos about himself using his Tesla on autopilot and so on. And unfortunately, he died as a result of a collision owing, it's believed, to be a fault in the sensor system. It was a bright, clear day. The sensors couldn't distinguish between the brightness in the sky and a tractor that was crossing his path, and the Tesla unfortunately went under the tractor, or I think the trailer, resulting sadly in Joshua Brown losing his life. Elaine Hertzberg, more recently in 2018 in Arizona, was a pedestrian. She was crossing the road, a four-lane road, wheeling her bike, and she was run down by a Volvo XC90 that was being operated by Uber. There was a driver in the driver's seat monitoring the vehicle, but from the data, it was clear that she didn't intervene in time as Mrs. Hertzberg walked across the path of the vehicle. She didn't brake until 1 second after the collision had occurred, and there was some steering, but only a second before. So there was then a failure to intervene. So it's a sad fact of life that even with technology as advanced as it is, that fatalities have been recorded even when this technology is barely in use. One aspect of today that I'd certainly like you to take away is at least some knowledge of the new terms that are in use. And here's a glossary. I've restricted it to a couple. Probably the most important ones for our purposes as lawyers and insurers dealing with personal injury litigation arising out of road traffic accidents. CAV, you will see written and hear an awful lot in the context of this type of legislation. Connected means very simply that it has a communications devices that enable it to communicate with its surroundings, most particularly other vehicles, highways infrastructure, signs, road signs, matrix type structures which might provide information about speed limits, for example. And it's even thought that potentially cyclists, pedestrians, and even pushchairs might in future be fitted with devices that enable them to communicate with other vehicles that have this type of technology. The A is simply for autonomous, and that's a vehicle that's capable of undertaking journeys safely without the need for a driver. The UIC is the user in charge, so turning back to Mrs. Hertzberg's incident, the driver of the Uber taxi would be the UIC in that case. So hopefully at a minimum, you'll take those two terms away and have an understanding of what those mean in the context of this type of legislation. Classification. Again, we can usefully spend a little bit of time looking at this. The Society of Automotive Engineers has produced a standardized form categorizing the different types of vehicle according to the technologies and really the intervention levels required in order for them to be operated safely. And they've produced a very useful graphic, which I shall move on to now. Now, just to give you a little bit of assistance in how we read that, you'll see the 6 levels. They start at level 0 along the top row. And in order to understand the level, you have to read down vertically. And let's start at the very beginning. Level 0, that is a common or garden car, lorry, truck, whatever vehicle, as used on the roads today. There might be some features that assist or support the driver, but they do nothing more than provide warnings and momentary assistance. So, for example, you may all have experience of automatic emergency braking systems where a vehicle spots that you're too close to something in front and it will brake for you. Blind spot warnings, as you indicate or move out of a lane, it'll pick something up alongside you in the blind spot area. Or a lane departure warning where the car is able, via sensors, to read the white lines or the curb, and as you get close to that, it will warn you that that's about to happen. And those are warnings that then require you as a driver to do something about it. And then we see levels 1 and 2. We're moving more now towards the ability of the car to correct itself. So at level 1, we have a lane centering ability, so that the vehicle, it doesn't just warn you that it's going out of its lane, it will actually steer itself to the center of the lane. An adaptive cruise control, where a car will actually maintain a specified safe distance from a vehicle in front. Level 2, we have both those features then in the car together. And at this stage, we're approaching a decent level of automation. I have hired cars in the past when I've had to sort of travel around to go to court and so on. And the car hire office that I use, I got to know them quite well. And a little while ago, I won't mention any names, but I was talking to someone behind the counter there about these various features. And I was told that there was a Volvo with really very high level 2 capabilities. And it had been picked up, this chap had picked it up from one of the other car hire offices to return to their own. And he drove the length of a road just with his hands off the wheel, and it pretty much drove itself with really a minimum of intervention back to where he needed to go. So we can see at level 2, we're already approaching significant levels of automation. Now, once we move into level 3, 4, and 5, we're now talking about driving automation properly as understood by the legislature. There is a problem with level 3, which I'll come back to. But at levels 4 and level 5, you'll note that the automated driving features there do not require you to take over any driving. In essence, the vehicle will drive itself. You don't need, subject to any regulatory standards that may be introduced, but you do not need to be capable of driving, and you're not required physically to intervene and drive. A level 4 or level 5 vehicle should start on your driveway and get you to where you are going without you doing anything. Level 3 is what's referred to often as a sort of rather murky middle ground, because it does require at points you to intervene. That's as far as I want to deal with the technical side of matters, and as I say, I'm keen that you have a basic understanding of the technical background, because it is important when we come on to consider the next aspects of this topic, which are again aims of this webinar, in particular an understanding of the legislation that is on the statute book, or is to be on the statute book perhaps, that will regulate this type of vehicle. And given credit where credit's due, the government has and I use this phrase advisedly, an oven-ready statute that deals with automated vehicles. The Automated and Electric Vehicles Act 2018, and it, as ever, it's abbreviated down to AEVA 2018. I'll just refer to it as the Act throughout this webinar. And it has a number of specific features, but and I leave aside the Electric Vehicles Act part of it for the moment, because that deals with matters such as charging points and so on and so forth, and it isn't connected necessarily to driverless cars and vehicles and possible liability and insurance issues. The automated aspect is, though, really what this Act does, and this is important to recall throughout, is that it introduces really a novel and groundbreaking insurance system of insurance for those vehicles, and how one is going to deal with questions of liability. The Act itself, so Part 1 deals with driverless vehicles, or CAVs, and it has 5 substantive sections to it. There are a further 3 sections which deal with interpretation and so on. But these are the 5 substantive sections you see in the Act. Section 1, we note there'll be a list of those motor vehicles capable of driving themselves safely. We have the definition of liability of the insurer, where an accident is caused by such a vehicle. Section 3 deals with contributory fault. Section 4 sets out exclusion, where there have been unauthorised alterations to or a failure to update software in the CAV. And Section 5 sets out the right of the insurer to claim, make a secondary claim, essentially, once they've settled the initial claim, to claim back against that person responsible for the accident. And I'm going to deal with these sections in a little bit more detail now. If you, as I say, if you come away with an understanding of the technical background to this and these 5 sections, then I think we'll have achieved what we set out to do with this webinar. The listing of automated vehicles. Section 1. The Secretary of State for Transport will maintain an up-to-date listing of the automated vehicles capable of driving themselves safely. And that will be a list under constant review. Importantly, this is a type of vehicle or a model. This doesn't refer to, this is not, for example, like the DVLA maintaining a register of every single car on the roads. These are all the types of vehicle that are deemed by the Secretary of State for Transport as being suitably safe when driving themselves, that they can be on the list. It's referred to as a list rather than a register. We have some clarity in Section 6, which is the interpretation section that I referred to earlier. The driving itself means that the vehicle is not being controlled and does not need to be monitored by an individual. Now, this moves on to our first actual conundrum with this legislation. And I'll make this point now. This legislation, this Act, is not yet in force, at least not substantively. I think the commencement provisions and those usual boilerplate type provisions that are necessary have been brought in, but the Act itself is yet to be introduced, is not yet in force. That's important to bear in mind. We refer here to SAE levels, so we're going to go back to that table that we looked at before, showing the various SEA levels. And we'll recall that the definition is that the vehicle's not being controlled and does not need to be monitored by an individual. So, on the face of it, it seems as though levels 4, well, certainly level 5 is a vehicle that under level 5 that can drive under all conditions is bound to be within the Act, and that's clear. There was some confusion over whether level 4 vehicles would be caught by the legislation. It was subject to some debate. Questions were asked while the Act was being debated. The initial answer was that it would apply to level 5. That was certainly that was what appeared to be the case. There's since been clarification that the Act will apply to levels 4 and levels 5. So the levels 4 and 5 vehicles will be on that list. There are queries about level 3. The problem with level 3 is, you'll note if we look at the second substantive row down, you'll note the small box below level 3 when the feature requests "you must drive." Now, it seems to me that if we go back to the definition, it simply falls without the definition of it being needed to be not needed to be monitored by an individual. A level 3 vehicle does need to be monitored by an individual. There have been suggestions, though, and discussions in Parliament that it might be that level 3 vehicles arguably fall within the scope of the Act. So that's a point to bear in mind. Let's move to the meat of this now, though. We've got a list on. We've got a vehicle on the list. An accident occurs. How do we deal with the question of liability? And there's the provision, and I'll let you read that for yourselves if you're not ahead of me in any event. When an accident is referred to, there's a further interpretation clause at section 8, and you'll see that accident includes more than one accident, and caused encompasses accidents that are partly caused by an automated vehicle. Essentially, what the Act attempts to do is provide a relatively simplified basis for insuring an automated vehicle. And it's a radical approach, really, because as you'll see, it's a liability which arises directly on the insurer. It's not a liability on the driver or whoever's the user in charge. It is specifically pegged to the insurer. It is the insurer that's liable for that damage. So when you're claiming, you'll be suing the insurer. And there is a further and it seems to me really quite problematic part to this provision, and it might just be that we're going to have to teach old dogs new tricks, but of course it deals solely in terms of causation. Nowhere in that provision is the word fault mentioned. So liability arises purely as a consequence of an accident being caused by an automated vehicle. And I'll come on to a Law Commission consultation on this in a bit more detail later. But interestingly, they point out that nowhere, well, it's clear from the Act itself, nowhere in the Act is the question of fault considered. The meaning of causation is left by the Act entirely to the courts. And the logic of this, it seems, is that the courts have been, over time, very effective at determining questions of causation. And so what is envisaged is that the courts will apply the usual tests for causation that we're so familiar with in the common law jurisdiction. The but-for test, of course, is the starting point. But also, we have those other factors, such as intervening acts and remoteness. This provision is going to raise, it seems to me, quite a lot of questions, though, which are going to be problematic for the insurance industry to deal with. Let's consider a case where an autonomous vehicle is driving down the road alongside a line of parked cars. A cyclist is coming in the opposite direction, veers towards the vehicle smacks into a parked car. Now, on one analysis, the start of the incident is the veering of the cyclist. But it's hard to get away from the fact that what's happened here is that the vehicle has driven into collision with the parked car, and if there is a claim for property damage, or perhaps if there's somebody in that parked vehicle, a claim for personal injury, that the automated vehicle has caused the accident. The but-for test is surely satisfied here. Combine that with the fact that the cyclist is unlikely to be pursued because of an absence of insurance, perhaps, or not being good for the money. Now, these are probably cases where, in terms of negligence, you'd have a sporting chance, as if the car was being driven by a human, and the human was confronted with an agony of the moment case, that in fact there is no negligence, there's no breach of duty, because what happened was that the driver reacted in the way that any reasonably prudent driver would do and avoided a collision with the cyclist. If one applies that, though, if one applies the provisions as drafted of the Act, it will see that the injured person or any other person suffering damage, maybe property damage, the person who owns the parked car has probably a good case, and the insurer of the automated vehicle is going to be on the hook probably for all of the damages. And I think when one analyses this section, it really is going to be agony of the moment cases that are going to cause difficulties for insurers, and how the landscape might change, because questions of standard of care and breaches of standard of care and of breach of duty aren't included here. And it's difficult to see that one can import those into the principle of causation without really stretching the definition of meanings of those principles. Another problematic area is likely to be that of contributory fault. And this is largely because there's had to be introduced something of a fiction. You'll note that what now happens is that the court has the capacity to attribute, reduce the amount of damages by reason of contributory fault. The way that this Act gets us to that point is that it pegs the amount of liability that would be determined, and that's why it refers back to the Law Reform Contributory Negligence Act 1945. It pegs that amount of liability to the amount which would apply to a claim in respect to the accident brought by the injured party against a person other than the insurer or vehicle owner. So we're actually being asked to imagine somebody else other than the insurer or owner of that automated vehicle. And the immediate reaction here seems to me to be that, well, who is this person? Who could it be other than a putative driver of the automated vehicle? The Law Commission were quite reluctant for that to be the case, though, because their point is that actually this is a bit of an undesirable distraction. Let's imagine a slightly different scenario involving a cyclist. Let's imagine a cyclist who's out at night in the dark and doesn't have any lights on, and they are hit by an automated vehicle. Now, under the provisions of the Act, what we're doing here is we're putting, it seems, into the automated vehicle, we put a human driver. And so when we determine the extent of the contributory fault of the cyclist, we carry out a balancing act considering degree of fault and culpability as a consequence, A, on the part of the cyclist of not wearing the lights at night time, and B, on the part of the driver of the vehicle, the fictional driver who failed to see the cyclist. Now, it seems to me that, and from experience, in those sorts of claims, by and large, there would probably be a relatively hefty degree of contributory fault against the cyclist. But there's a strong argument here that, let's say the automated vehicle is equipped with something called, another acronym, LIDAR. Now that's a laser system which operates regardless of light conditions and maps a 3D surroundings. And it's thought to be that that's really one of the key types of technology for the automation of vehicles, so that they are autonomous, that will become incredibly prevalent. Now, that system should work. That system should have picked up the fact that there was a cyclist there. A human driver might have trouble because they simply don't have the capability of an LIDAR system. Isn't there a question here that actually the relative blameworthiness of the vehicle and the cyclist should be different in this particular case, because the LIDAR should have picked up the cyclist? An argument perhaps for claimants there that their injured cyclist shouldn't be subject to the level of deduction that would ordinarily apply where they've been hit by an automated vehicle which is equipped with state-of-the-art LIDAR systems. Interesting questions. I'll move on now for the sake of time and getting through the last few slides and so on to the next part. There's also an exclusion potentially for insurers where the software has been altered using an unauthorized type or method, or where there has been a failure to update the software. And you'll see the specific provisions there. So you'll note that here, the insured person injured in an accident may have their damages excluded or limited if they have altered in an unauthorized method the software of that vehicle, or they have failed to keep it up to date. That will be, I suspect, of particular interest for insurers, and also, of course, for example, claimants and defendant solicitors. The claimant side, the first port of call when something goes wrong in an automated car is going to have to be a pretty comprehensive trawl through the safety logs and making sure that A, the software was up to date, and B, that there haven't been any unauthorized alterations. And the same process will no doubt be carried out on the defendant's side on the basis that there may be an exclusion. As I said at the beginning, it is a new system of insurance coverage, and it takes the idea of fault out of matters to a degree, and puts the onus very clearly by way of a direct action onto the insurer of the vehicle in question. That is, though, subject to the ability of the insurer to pursue others who may be responsible for the accident. So so that is preserved. It is very similar to the common law situation in any event. There probably are interesting questions here, though, about who may be liable. Other drivers certainly may be liable. If there's a failure in the automation system, though, if the insurer is paying out straight away, might there then be a secondary claim made against the either manufacturer of the software, the party that was going to update software, the manufacturer of the vehicle itself? This for the insurance industry is a big question, and it's one that is prayed in aid of the logic of Section 2, which we've seen imposes that quite stark liability on the insurer. And what is said is that it would be unfair to impose on injured drivers, and passengers, and pedestrians, cyclists, and so on, the burden of proving a product liability claim against, for example, Tesla, Volvo, whoever it may be. What this system does is it generates a payout, a liability finding for that injured party, and puts the onus then onto the insurance industry to pursue any product liability issues. That's the underlying rationale. It's not necessarily straightforward, though. I'll touch on that maybe at the end. I'll just move on now to this, which is, as I say, we've got an oven-ready item of legislation on the books. There is a very important process that's been running parallel and subsequent to that legislation, and that's the Law Commission Consultation on Automated Vehicles. And the purpose of that is it covers really the whole gamut of of issues dealing with automated vehicles, from licensing, regulation, highways infrastructure, and so on, which is certainly beyond the scope of us discussing it in a sort of personal injury insurer type context today. It also touches a lot on issues of civil liability, criminal liability, and the like. There have been consultations already with responses. The timescale for the final report is that I think by the end of this year, the final responses should be into the consultation, with then the Law Commission producing its final report in 2021, so at some point next year. And certainly, so far as my reading of the literature is concerned, the Law Commission are interested in how we deal with the contributory negligence point, because they find it complicated, difficult to understand at times. One point I should have added is they moot the possibility, does actually the provisions of the Act open up the prospect of 100% reduction in liability by way of contributory fault. So expect to see recommendations from them touching on that issue in particular. So far as causation is concerned, from what I've seen and understood from others about the Law Commission's point, is that so far as causation is concerned, they are more than happy really to let common sense and fairness considerations by the courts take precedence there, and for the various factual situations to work themselves out in court, although they do note that that's of pretty cold comfort to an insurance industry that obviously would like something more by way of certainty than that. Some problems going forward. Well, what happens when there is no insurance in place in the automated vehicle? The position is unclear. The role of the MIB in those claims has not been crystallised. We have the legislation, and there are, as I understand it, consultations between government and the MIB as to how uninsured CAVs, which would have been covered or should be covered under the terms of the legislation, will be dealt with. And that's going to be an important development. Product liability claims, as I say, it's a big topic that, and probably could take up an hour in and of itself. There are various options in a product liability claim. The immediate cause of action would be under the Consumer Protection Act, but of course that's for consumers, and has very limited, well, certain restrictions on what one can recover. Now, let's remember that it's the insurer that's going to be trying to recoup its outlay most of the time. For the insurer to, well, the insurer is not going to satisfy the definition of consumer in any event. Whether they can bring subrogated claims in the name of the insured driver is perhaps the approach there. But there are restrictions. So, for example, any commercial property damage is excluded, and likewise, damage to the actual defective product itself is excluded as well. Well, if the defective product is the whole car, and you write off a £50,000 Volvo, the Consumer Protection Act isn't much help there if that money's all gone and the vehicle's written off. So tricky issues there. There is the ability to bring a contract claim, but again, privity of contract may cause some problems here. There's the general negligence claim answer as well. But as I say, that those product liability claims, those are likely to be questions for insurers to take by way of group action, rather than something that you will be encountering with individual claimants in particular cases. And finally, although certainly this isn't exhausted by any means list of difficulties, no criminal offences are dealt with in the legislation. It will be interesting to see quite how that is dealt with. It may well be that there has to be further legislation dealing with, for example, individuals who tamper with a CAV, that tamper with the software, those types of matters, which are novel and innovative and come about simply as a consequence of new technologies, and probably our criminal framework, which operates and covers pretty comprehensively everything from a mechanical point of view, is going to have to catch up the electronic age. Those cover, I sort of aimed for about 45 minutes. There's an awful lot to cover. I hope, firstly, you've got an understanding of the technological background, and secondly, and I hope most importantly for your purposes, you've got a bit of an understanding now about the legislation, about the 2018 Act, and how, in insurance terms, it is a very brave new world. I've just noted there's a question here from Jason Palany. Thanks, Jason. Is there any discussion as to whether a full UK driving licence will be required to be in a level 4/5 vehicle? That is one of the hot topics, and for a number of reasons, actually. And one of the driving forces behind level 4 and 5 vehicles as a force for good is that people who might otherwise not be able to drive are able to get themselves around. So the requirement that you would have to have a full UK driving licence isn't going to help somebody who has, for example, visual impairment, which might prevent them from having a driving licence. Those types of issues. Of course, one of the great benefits of such vehicles would be that it would enable far greater freedom and equality for people who have to deal with difficulties that perhaps prevent them from driving. So it's certainly being discussed. The regulatory framework hasn't been set out in any detail. That's very much a matter that's up for consultation at the moment, interestingly, in terms of licensing and regulation. So we'll probably see more once we get the response from the Law Commission to the latest round, and then it will all be dotted and I's dotted and T's crossed at some point next year. I think the next steps are going to be regulations. We've got the legislative framework set out by the statute. This is very much going to be a case of regulations introduced by the Secretary of State for Transport, introducing those parts of the Act that we've touched on, but also setting out a clear regulatory and licensing framework. I don't know if there are any more questions. You're more than welcome to ask. All I'd say is thank you ever so much. I appreciate that it's a lovely warm afternoon and you probably all want to be off somewhere else with obviously no more than 5 people. Thank you very much for tuning in. This webinar will be available as a recording if you could bear to sit through me talking for 45 minutes again. But otherwise, thank you very much for your patience. I will now stop my screen sharing so that I can operate my mouse again. There we are. I think we're all finished now. I will close off the meeting now, unless Kelly, who our marketing manager, who I'm sure you all hear from regularly, tells me otherwise. I can't see anything. In which case, I'll say thank you ever so much and goodbye.